I'm the law school and I'm the moderator of this panel. And we are so lucky today to get to hear about the current projects of these three scholars that build on their prior work on conceptions of constitutionalism, the courts, and legal authority. All three of them have done extensive scholarly and public-facing work about how those things facilitate or hinder shifts to more democratic modes of self-government in a very refreshing and realist way. So today we'll get to hear more about how they trace the historical roots of our contemporary juristocracy and suggest interventions, their suggestions for interventions that reimagine the relationships between legal institutions, constitutional theory, and popular sovereignty. We'll start with Niko Bowie, who is the Louis B. Brandeis Professor of Law here at Harvard Law School, who's, I think, going to speak on the book he's working on with Daphne Renan, who's also a professor here. And then we'll hear from Ryan Doerfler, who's also a professor here, and Samuel Moyn, who's the Chancellor Kent Professor of Law and History at Yale. His new book, Liberalism Against Itself, Cold War Intellectuals in the Making of Our Times, is going to be coming out this fall, so look for it. Without further ado.
Go ahead. Oh, okay, so we're just going to reverse the order. I insisted on being like the forgettable opening band that are waiting to end before the others go. Well, thanks to the organizers, thanks to K2. So Ryan and I are writing a book together, and Daphne and Niko are writing a book together, and they're different, but we just thought we'd throw out some of the early ideas in our case and medium-term ideas that Daphne and Niko have, and then promote a conversation. I guess the topic is what views of the Constitution and of constitutionalism in general should adherents of the law and political economy movement have, and I'm just scene setting for Ryan to answer from our perspective, because we've done some prior work that has prepared the kind of project in constitutional theory we're trying to devise right now. On one end of the spectrum, we've opposed constitutionalism, not just called for a movement like this to denounce the US Constitution, but to attack the very idea of constitutionalism and abandon it except for defensive purposes. And that's a live debate then set up in these circles because there are also calls these days for a constitutional political economy trademark. And since Willie's sitting here, we can get rowdy on that if you like. But we think that devising a leftist constitutionalism is a mistake in principle and strategically. And so we've tried to argue that case. And then we've let's say paid attention to the opposite end of the continuum of projects you might imagine, which is to think about the ways and means of Supreme Court reform and tort reform generally. And Ryan and I have worked on the Supreme Court and especially on the constitutional power of judicial review that the Supreme Court exercises and argues that it ought to be abolished or if not diminished. And we've reviewed various devices that might be deployed or supported by this kind of movement, jurisdiction stripping or legislative override to effectuate those ends. But in between, we're very interested in the liberals, those in the center of the political spectrum, those who control the law schools, who argue for the democratic credentials of constitutionalism. And we're devising a project that's really just a constitutional theory project intended to present a challenge to the view that democracy depends on constitutionalism or that constitutionalism is indispensable for our democratic future. And to set Ryan up, I'm just going to say a few words historically, because it strikes me that it's very parochial, that for the past 50 or so years, it's been credible that constitutionalism serves democracy. And I just wanted to lay out some stages of the history of thinking about constitutionalism that should make that seem a somewhat strange belief. And then it's one that we want to go on and undermine theoretically, and Ryan's going to talk about that part. So consider, let's say, 3 stages. In the first, before modern times, roughly, the idea of a constitution was just the idea of the regime under which a community lives. Absent was the idea that there were 2 tracks for law, higher law and ordinary law. And absent was the idea that higher law was about entrenching basic values. And so there was no formal entrenchment in pre-modern law of the kind that ends up defining constitutionalism in the second 2 stages. Now, I want to be clear, there was functional entrenchment, and we might want to advocate for such a thing. All I mean by that is that there are in every regime things that are harder rather than easier to change. I think most of those are bad and should be changed when they're harder to change. But you could imagine that you'd advocate for making some things harder to change functionally. But what we oppose is the idea of using a text or using even an unwritten constitution to formally entrench anything. And that's why we're concerned about the second and third stages. So in the second stage, these new ideas arose. I actually think they have roots in theology. Christians had a problem. They believed in an omnipotent God, but they also wanted to believe in a stable, natural, and moral order. And so they said, what if we imagine that God works in 2 ways? He can do anything in the first way, using his so-called absolute power, but he can also ordain order. And it's no accident that our founders say they ordain our Constitution. And this is the idea of higher and lower lawmaking, or dualism, as it was called a few decades ago. And it's introduced, and it then allows for something new, which is the formal entrenchment of constitutionalism, which had not been available to imagine in the first stage. Now, what's interesting about the second stage, as I'm presenting it, is that everyone thought the point of constitutionalism was not to have democracy. In the first stage, with Plato and Aristotle and so forth, no one wanted democracy either, a democratic regime. But in the second stage, it could be acknowledged that there's popular sovereignty, like, the people rule. But in the using the devices of constitutionalism, it could be said that the people found the legal order. They may have done so once or multiple times, but they can't have much access to governance now. And so this is I think, pretty interesting, because it makes it puzzling that you could ever think of constitutionalism as a democratic project. Of course, it could be democratic in the sense that the people founded the system, but they don't get to rule. And it seems as if in the debate, roughly from Thomas Hobbes through the middle of the 20th century, no one's out there saying constitutionalism is democratic in order to allow the people to control their government, other than founding it, possibly changing it every once in a while. I'll just read a quote to this effect from the early 20th century case of Mueller v. Oregon from Justice David Brewer. The peculiar value of a written constitution is that it places in unchanging form limitations on legislative action, and thus gives permanence and stability to popular government, which would otherwise be lacking. So I think what's interesting about this era is that there was consensus. Most people, most constitutional lawyers backed constitutionalism precisely because it didn't allow democratic self-rule to happen. And Democrats rejected constitutionalism very often because they thought it was an obstacle to popular self-rule. So what we'll want to say is that something changed to make our own recent theory possible, and it's roughly since the end of World War II. Since World War II, most constitutional theorists, especially in the elite spaces we're sitting in now and inhabit many of us in our daily lives, thought they could keep fundamental law and make constitutionalism democratic so that it would enable self-rule more than anyone had assumed it could before. And so our project is going to be about trying to understand how a series of thinkers, really for generations, made this equation, constitutionalism and democracy could go together. And our thesis, very briefly, is going to be that the record of trying to square these two commitments really show that a lot of people say they're Democrats, but are actually liberals. They still want to thwart popular self-rule, and they redescribe their positions as Democratic, most commonly through a kind of historical claim that you find in the work of my colleague Bruce Ackerman, that sure, the people can always come back when push comes to shove, or in a kind of normative claim that you find in Jürgen Habermas or in the work of other colleagues of mine, Robert Post and Riva Siegel, that democracy has preconditions. And the purpose of constitutionalism is not to thwart democracy, but to make democracy possible in the first instance, or sometimes in a descriptive mode. You find this in Robert Dahl and many successors who say that, well, constitutionalism, which empowers judges, will reach the same results that democracy would, and so there's no problem. And we want to challenge all three of those positions and argue that if we want to be Democrats, we have to abandon not just our constitutionalism, but the very idea of a higher law that is hard to change.
I'll pick up where Sam left off. I mean, before I get into the specific comments, I think one thing that might be useful here, because I think what all of us wanted to continue this panel as like a conversation with you all rather than us talking at you primarily. And so I think one thing at Sam's and our sort of, I think the highest level of our sort of project is a critique of this idea of constitutionalism, but also like a particular conception of constitutionalism, which as Sam says that sense of constitutionalism is on the one hand like a modern advent, but on the other, like entirely sort of naturalized at this point within our sort of constitutional, like talk about constitutional discourse. And so like one sort of, for the discussion we might have is whether there is a different, less entrenchment centric conception of constitutionalism that might be worth recovering. But at the same time, I think part of our project immediately is to try to denaturalize or call into question the sort of entrenchment centric understanding of constitutionalism that I think people just, again, at least especially in the United States, just treat as coextensive just with the idea of a constitution. Okay, but just to get in then to backing the liberal theorists, building like what I said, so after recounting the transition within constitutional theory away from a more anti-majoritarian, anti-democratic understanding of constitutionalism and towards a purportedly quote-unquote democratic constitutionalism, the middle chapters of the book are going to describe the ways in which these new purportedly democratic theories either reverse engineer a definition of democracy in an effort primarily to preserve a broadly jurisdicratic system, or alternatively, the way that those theories rely upon undefended and often just unstated, but highly questionable empirical conjectures that make juristocracy seem normatively attractive. attractive. And so this is potential fodder for conversation. I'm just going to mention two such examples. So first, and maybe most sort of numerous, most significant, various liberal constitutional theorists, including most famously John Hart Ely, offered a concession, seemingly important concession, that the imposition of values, including liberal values, from the bench is democratically illegitimate as a rule. But, important qualification, that in the case of certain vulnerable populations, and in particular for Ely, vulnerable minority population, judicial intervention to promote the interests of such groups, in fact, works to counteract pathologies within our democratic processes. And so, under the heading for Ely of representation reinforcement, serves to enhance or improve our democracy rather than counteract it. Okay, so most charitably, this, I'm sure, is you all familiar narrative of courts as necessary or critical protectors of minority interests. Effectively reduces the claim that state officials on their own are more attentive to the interests of those vulnerable populations than are ordinary citizens. Which is to say, somewhat less politely, that ordinary citizens are simply more bigoted than government officials. Now, one can see, of course, why such a flattering and meritocracy reinforcing narrative would be appealing to the liberal professoriate and more broadly to the liberal elites. And this, again, I think entirely familiar sentiment is, I think, fair to say, really a mainstream of contemporary establishment Democratic Party politics. And yet, and here our work connects directly with work that Niko has done both independently and with Doerfler and that narrative simply fails as a historical matter, right? And that with at least in the United States, with the judiciary in this country, has systematically operated as a reactionary force. Not only failing to intervene on behalf of racial and other minorities at critical junctures, but I think even more importantly, actually affirmatively intervening to negate efforts by Congress in particular to promote the interests of those populations through, again, ordinary legislation, right? Just ordinary lawmaking in instances like the Civil Rights Act, the Voting Rights Act, or maybe less obvious, let's say the Medicaid expansion of the Affordable Care Act. Okay. So that's on Ely. Second, more explicitly under the heading of quote democratic constitutionalism, liberal constitutional theorists like Robert Post and Reed Siegel or Bruce Ackerman, again concede, make an important concession that the judicial administration, especially of the big constitutional text, does in fact amount to lawmaking without their direct democratic input. Right? So in that sense, there is a democratic concern. Because, however, these theorists argue of indirect democratic input through the judicial appointments process and other channels, these theorists insist that a broadly juristocratic regime is not only defensible as a matter of democracy, but is in fact superior to a system of constitutionalism, or as Sam and I would probably prefer, a system of fundamental value articulation through ordinary legislation. And the reason, according to these so-called democratic constitutionalists, is that this indirect democratic approach to the articulation of fundamental values ensures that such articulation is done, quote, responsibly, and that significant changes to society are made only after years, if not decades, of endorsement by popular majorities, as reflected through a continuing series of judicial appointments, or perhaps for instances of historically significant supermajority decision making. But again, sort of either over time or in numbers, we need sort of extraordinary commitment to societal change in order for that change to be made quote responsibly. Now, in telling the story, Post, Siegel, and others frequently contrast the sort of responsible democracy with what they call quote crude majoritarianism. Sometimes, apologies for triggering Sam, going so far as to characterize majoritarianism explicitly as fascism. Now, notwithstanding this rhetoric, Sam and I argue that drawing, for example, on work by Jonathan Gould and Dave Posen, that this sort of quote responsible democracy model is just fundamentally at odds with any plausible theory of progressive, let alone left or radical political change. And that the imposition of additional veto gates, which again is just a practical effect of the sort of indirect approach to fundamental governance, worked against the proponents of state intervention, and were generally against any sort of mass and working class political movement that is operating in an already hostile political environment dominated by money interests. Okay. And so there's more we can say about, again, this sort of failings of liberal constitutional theorists, but I'll leave it there.
Great. So thank you all for being here. This has been a really fun conference just to meet people in person who I've only gotten to know over Zoom or through email. So I just really enjoyed this weekend. I'm looking forward to the conversation with all of you about these projects. And thank you so much for Casey for moderating this conversation and being here too. So the book that I'm writing with Daphne Renan is tentatively called Supremacy: How Rule by the Court Replaced Government by the People. And it's oriented toward a popular audience, and it's mainly coming from a historical background rather than a theoretical background. But there are two laws, contemporary laws, that we have in mind as both the illustration of the problem that we wrote, or that we're writing this book to address, as well as a path forward. So one of the laws that we have in mind for why we're writing this book is the Voting Rights Act. And the Voting Rights Act of 1965, extremely important legislation for introducing multiracial democracy in the United States. Most recently reauthorized by Congress in 2006 by near unanimous majorities in the House and Senate, affirmed by the Supreme Court at various points. It's an incredibly important law, incredibly important promotion of democracy in the United States. Yet in a decision like Shelby County versus Holder in 2013, all it took was 5 votes on the Supreme Court to hold that part of the law was no longer appropriate. And because of that decision, part of the law could no longer be enforced. So Congress had defended this law as saying this is appropriate for enforcing the 15th Amendment. 5 justices on the court disagreed after unanimous courts beforehand had said, yes, we agree that this is appropriate. And so because of a dispute over the meaning of the term appropriate, what is appropriate, 5 justices could overrule the will of both houses of Congress, the president's past courts. And that decision is not only a dramatic sort of illustration of this political power, the ability to prevent this sort of law from being enforced by anybody, but it's also a form of entrenchment, because to overrule a decision in Shelby County, just as the holding of Shelby County, today's Supreme Court, if it wanted to, could do so just with 5 votes. It could say, you know, we got it wrong in 2013. 5 of us think that this is appropriate, so now it can be enforced. So from the court's perspective, it just takes 5 people to change the law. But for the rest of us, if we want to overrule a decision like Shelby County, we need supermajorities of the House, a supermajority of the Senate, and supermajorities of the House and Senate of 3/4 of the states in order to propose and ratify a constitutional amendment reversing the decision. So it's a tremendous amount of power illustrated in a pretty straightforward example of judicial review like Shelby County. Another law that we have in mind, I guess it's more like a bill is appropriate, is the Women's Health Protection Act. So after the Supreme Court decided Dobbs and overruled Roe versus Wade, members of Congress proposed legislation saying let's protect some of the substance of the prior regime through statute. And one of the responses among many people on the Hill to the Women's Health Protection Act is, what's the point? Because if we pass this legislation, the Supreme Court is obviously going to be pretty hostile toward it and might invalidate it. And so someone could respond to that kind of cynicism by saying, well, how about you just amend the Women's Health Protection Act to get the court out of it? You could pass a version of the Women's Health Protection Act that enforces its terms through agencies, that minimizes the role of judicial review, that creates a new court to review it if you need to have a court involved, and staff the court with members of people who you think would be favorable to the law. But the response to that is, I don't know, it seems like it takes away something really important about American democracy to try to insulate this sort of legislation from being invalidated by the Supreme Court. So even before a law is passed, there is this cynicism that a democratic piece of legislation can be enforced without the approval of at least 5 of the votes on the Supreme Court. So both of those laws sort of illustrate for us the problem. And the problem is, like, why do we accept the status quo? Why do we accept this system in which 5 people, by virtue of their position, can force the rest of us to have to go through an incredibly convoluted process to overrule them, including when the sort of outcome is supported by supermajorities of the population. And so we describe the argument in favor of the regime that exists now as judicial supremacy. That the idea that when there is a disagreement between the Supreme Court and Congress over the constitutionality of legislation, so in the context of the Voting Rights Act, what is appropriate, that the Supreme Court's view should carry the day. And we're approaching the question of judicial supremacy from a historical perspective. We're asking, where did this come from? Did everyone always think that judicial supremacy should be the governing rule? And from a comparative lens, the United States is sort of an outlier in terms of both how much power it gives to its highest court, as well as how difficult it is to amend the Constitution. No other government, as far as I'm aware, has just concentrates so much power in the hands of the court, given how hard it is to overrule it. And so looking at the history of judicial supremacy, we focused our attention on groups of people who have been dissatisfied with the constitutional order and want to change how it is enforced. So starting with abolitionists before the Civil War, focusing on labor organizers in the early mass labor movement after the Civil War, civil rights leaders around the turn of the 20th century, women's suffrage activists, and through the 20th century, other groups who have had ambitions for enforcing the US Constitution in a particular way. What was their theory of change for how they were going to achieve their vision of how the Constitution should be interpreted? And one thing that we found that's really interesting to us is a very common thread on the left through the early 20th century of a version of constitutionalism that we describe as political constitutionalism, borrowing the term from comparative constitutional law. But thinking of constitutional change not as something that goes through the courts, but as something that has its first engine in public opinion. And then using public opinion through legislation and organizing and other active means of mobilizing it to change the meaning of the Constitution. So for someone like Frederick Douglass or Garrett Smith in the 1850s, even before a decision like Dred Scott, the question of how to get the Constitution to abolish slavery was not talked about in terms of, well, if we can get a great case to the court, we can try to work our way through it. And the response to Dred Scott in 1857 was not, let's pack the court or let's try to change who's on the court so that it issues a better decision. Rather, they had a pretty realistic understanding of their position. So Garrett Smith in 1858 said, we have no power. We have no political power at all when it comes to looking at Congress or the courts or the presidency. Everyone seems to be against us. But what we do have is control over public opinion. We can change public opinion. We can push people to get to the ballot. We can try to influence how politicians are viewing this. And if we get enough politicians in Congress who share our views, we can force them to start legislating in a way that reflects our understanding of what the Constitution requires. So we call it political constitutionalism in contrast with legislative constitutionalism, because sometimes these groups have to disagree with what the Congress is doing. So these are people who are very opposed to something like the Fugitive Slave Act of 1850. The view is not whatever Congress does governs, but rather the Constitution should be amenable, or it should be amendable by the public here and now, and not through this crazy counter-majoritarian process of going through the very rigid form of Article 5. So on a theoretical perspective, what the crux of the book is just marking the history of judicial supremacy as a reaction to this kind of rhetoric. That judicial supremacy, we argue, really took hold of American culture, not after Marbury in 1803, but rather during Reconstruction, when the Supreme Court was one of several engines used to try to undermine the first federal Civil Rights Act or Voting Rights Act from the 1870s. And that judicial supremacy is better understood as part of this conservative backlash to progressive organizing, rather than as this keystone of understanding constitutional democracy. But at the same time, we're not opposed to constitutionalism. We don't actually take a view that treats constitutionalism as sort of equivalent to the structure of the US Constitution, but we are approaching this from the perspective of democracy, and which we define in line with Daniel Allen or Robert Dahl in terms of political equality, the power of people in a community treating one another as political equals, to have equal power to make decisions in the community. And we think that that kind of definition of democracy translates into a version of constitutionalism that's very different from the kind of entrenchment that we understand the US Constitution through judicial supremacy in two important ways. So one is from a contemporaneous perspective. We object to, and so the end of the book is going to make a prescriptive argument. We object to a version of constitutionalism in which interpretation is concentrated in the hands of a very unaccountable elite. That in terms of thinking of what should the Constitution mean going forward, that entrenchment is a very bad thing for political equality because of the way in which it reifies and gives tremendous power to a handful of political minorities. But we also think democracy has an important dimension across time, and that it's important for one generation to be able to look at the structure around it and have the same power to change that structure as previous generations had. And so I think that Daphne and I are very much with Sam and Ryan in terms of objecting to constitutionalism as entrenchment. I think all four of us are on the same page that to the extent that law is used to disable the ability of organizers or political majorities today to legislate, that it's hard to square with democracy, nor should it necessarily have to be squared with democracy. But we do think that constitutionalism provides a good vocabulary for describing the project of someone like Douglas or Smith in terms of using the Constitution as a vehicle for organizing public opinion and making popular change. And so I wouldn't say that we're using constitutionalism defensively so much as we are trying to reinvigorate an older strand of constitutionalism in this country and say, you know, the response to something like Shelby County is not let's pack the court, but rather ask, why does the court have this power? And legislate despite it. And our response to something like the Women's Health Protection Act is, okay, let's dare someone to stand in the way of a mobilized public. But that the Constitution does provide a useful frame for organizing change that we hesitate to abandon. And ultimately, our goal for the project is to encourage everyone looking, you know, in this room and elsewhere to see ourselves as part of an empowered public and not take for granted the cynicism that comes from thinking that we can only make change when, you know, someone happens to die.
Thanks, Niko. On that note, I know that lots of people in this room have questions and that you all wanted to have a conversation with the audience. And so I don't want to stand in the way of that, but I do want to ask one question first, which is just, Sam, you did promise us devices, to talk about devices, and I think a question probably that a lot of people in this room have is about how one would get there, right? So don't get me wrong, I think placing in question ideas that have gone undisturbed as a fundamental part of legal education and practice for decades is extremely valuable and does a lot more work than anybody thinks. But how would we get towards weakening something like judicial review? I think probably a lot of people here would like to know. And so I'm just going to ask you to talk a little bit about that. And even you started to talk about this, but attached to that, I mean, you all have used history so effectively to show how these ideas are not necessary, right? But the product of contentious politics, right? And it gained power through your naturalization. Niko, you started to talk about how looking at history gives some clues to how we might seek to transform the kind of order that you're critiquing, but I'm interested in hearing from Ryan and Sam about that as well.
Well, no, I mean, I think we actually agree on short-term steps, even if there's some slight tension about whether to abandon constitutionalism at the end of the day, because obviously most people are still caught up in the matrix, and we're willing to offer them a step-by-step way out. So on the kind of side of constitutional power, Niko alludes to a device you might attach to the Women's Health Protection Act to protect it. Channeling jurisdiction away from the federal courts, to the extent you think is constitutionally viable, or stripping jurisdiction, or requiring a supermajority rule of for the Supreme Court to invalidate crucial legislation, or a legislative override of the kind the right is entertaining in the state of Israel. These are steps that I think should be considered, and we don't know where they lead. I mean, in their effect, they return power to the present majority, which is all that even in our most radical moments, Ryan and I are calling for. On the statutory side, in a sense, it's an easier sell because in theory, the legislature should control its statutes and not allow their evisceration by courts, which is happening on a daily basis. And so there have been interesting proposals to allow the fast tracking of statutes that clarify the legislature's intention when legislation has been gutted by adversary courts, and we support those, and we're part of some discussions with activists about what exactly to prioritize, what sounds good, what sounds radioactive. We're theorists, so in the end, we're kind of not getting into great detail about these steps, but clearly they're necessary. And there's also might be some tension down the road about, well, what if they're successful? What if there is a mobilized majority like there was in the last instance in this country in the 1930s to challenge court power? We're not there yet, but we need to have our ideas, if not agreed upon, then at least ventilated in spaces like this and amongst political activists to be ready for such an eventuality.
Yeah, just to add, so one on mechanism. So I sort of co-sign everything that Sam said, but just an additional mechanism that Niko actually mentioned in his remarks in the statutory context is, I think, it's an important step to take, is to sort of start becoming cognizant of the reality, but then sort of embracing further the idea of administrative agencies as the primary side of statutory implementation and articulation, right? Because I think one response that we often got, as Sam said, the initial wave of work that we did together had to do primarily with constitutional cases, which, given the sort of outsized sort of role of constitutional cases in the public imagination, I think it made sense. But then a response that we would get would be to say, like, well, okay, great, that's fine, but even if you take away the power of judicial review, courts will just, like adopt stilted readings of statutes and get to the same place through, again, their statutory interpretation. To which our response is to say, sure, but there are analogous mechanisms to put forward. And again, so again, just that in the constitutional context, we want to channel interpretive authority away from the court and to primarily the Congress. So too by analogy in statutory cases from the court to administrative agencies. Okay, so I guess I'm interested in you asking also more of like a political question, like how do we sort of build a political sort of movement that could actually get us to this place? And I think it's a great question, and it's hard, I think, because I think the landscape has changed. Because I think when, like, Sam and I started thinking about this in, I guess, late 2019, early 2020, and initially there was very little interest in the work that we were putting out, and then Ruth Bader Ginsburg died, and suddenly tremendous interest. And both, I mean, not just in sort of cynical, like, oh, like now I don't like the outcomes that are coming, but I think also it seemed like there was a real moment of possibility, right, with the 2020 election approaching. It seemed like some people were forecasting sort of like wave-like election, Democrats could have the huge majorities in the Senate. Maybe this is a real moment where this kind of change could happen. And I think initially, sort of our hope was to kind of like ride that wave of like elite liberal dissatisfaction into a democratizing change. Then you get the 2020 election results that are greater than majority in the Senate. It seems like now the time horizon for this project is significantly longer. And so I think that, to my mind at least, like changes the political calculus. And I think an important project going forward, and that's what I think it's helpful to talk about in this space like this, is I think the court reform movement needs to do a much better job about being grounded in a broader like mass politics, right? Because I mean, it's amazing and fantastic that like places like the New York Times or the Atlantic will publish really critical work in this space. On the other hand, right, that readership is not enough. if we're gonna actually translate this into the real, into a sort of to actually implement these ideas. And so I think that's something that I think we need to spend much more time on going forward. And again, that's why I think you really want to invite conversation with the people in this room to figure out how best to do that.
One thing I'll just add is, like, I think that history is really valuable, not just for denaturalizing injustices in the present, but also offering models and examples of how seemingly radical action is actually quite traditional. And so one fascinating thing is like looking through archives about the history of judicial supremacy is how much opposition there has historically been through the 20th century. So like the Socialist Party repeatedly as part of its platform, including 1912, 1916, as a platform, the Supreme Court and federal courts should not have the power to invalidate federal legislation. The response to a decision like Dred Scott was, I mean, partly the Civil War, and then partly a resistance to the idea that we need to wait for the court to reverse itself. Congress passed legislation that abolished slavery and encouragement, precisely what the court said it couldn't do. When the court struck down the federal income tax, the Supreme Court said Congress can't pass an income tax. So candidates ran for president repeatedly on the platform of what the heck is happening? Like, how does the court have this kind of power? And the fact that the 16th Amendment ended up overruling that decision was taken as a real indictment on the American political system. Like, think of all the work we had to do to overrule this crazy decision. And so today that like is seen as controversial to criticize the court, or it's associated with like autocratic movements elsewhere, like, oh, you take the court out, you take democracy out, which may be true in context, but it does not, I mean, in a context of autocratic movement, but it is not like the court is associated with democracy to such a degree that challenging it is seen as undemocratic. I think precisely the opposite is important to emphasize. And I think that it's part of a mass politics that opposition to the court's power is a prerequisite for achieving any kind of popular politics going forward.
Thanks, you all. There's a question up there.
Thank you so much. This has been really fascinating. My question really is for Ryan and Sam. I think it's one thing to say that constitutionalism in practice attenuates popular energy, right? That's quite different from saying that as a theory, right, something inappropriate about it. Rather, it attenuates popular energy in a manner that adversely, that adversely impacts progressive ideals, right, or progressive ideas about progressive goals. And to say that in theory there's something wrong with it. It seems to me that you're making the latter claim. And in making that latter claim, I suppose my concern is first, how do you, provide legitimacy to popular energy if you get rid of constitutionalism? And secondly, how do you impose limits on popular energy? Or indeed, whether you think it makes sense at all to impose limits on popular energy? Because one can imagine a situation, and I don't think it's too radical a notion, a situation where the constitution of the majority is quite different from what currently exists in this country, right? And that the majority indeed has ideals that are contrary to the theories, the notions, the goals of many of the people in this room, right? And it seems that that's one of the things, right, that constitutionalism would sort of one of the points of constitutionalism to begin with is sort of to enable sort of get back and forth within the system, right? Sort of certain factions, right? Minority factions specifically, right? And so really this is the point, this is the question I'm really trying to get at, right? Two questions I'm really trying to get at. Number one, where are you going to draw legitimacy from if you get rid of constitutionalism? Secondly, do you think there's the need for limits at all? And if you do think that there's a need for limits, where are you going to draw that from? That makes sense.
Excellent question. Should we answer one by one, or?
I think answer this one and then maybe.
Okay, no, it's an excellent question, and that I just offer a couple of thoughts. One is that we're only interested in formally entrenched limits, just because our view is that in principle and in history, those have served the wrong people. And that was sort of the point of my little historical, fairy tale, that, people like Justice Brewer thought, limits would be an insurance card against the mob if they wanted property. And it's kind of amazing that this view was rehabilitated on behalf of minorities, because it doesn't seem as if those kinds of ideas have actually served the vulnerable and weak. And so we think it's better to place a bet on the current majority. Now, there can be functional limits, and maybe we celebrate when, if it should happen that hierarchy it loses, that limits on hierarchy are functionally entrenched in some political order. But we don't think the bet should be placed on judges to police formal legal limits, just because they don't provide the goods. Now, of course, there are risks in our proposal, but there are risks in the current system, and judges are doing grievous damage, policing formal limits, and going back to Justice Brewer's views in the new Lochner's, invalidating this law and that, in the name of moneyed interests. That's constitutional law as of today. It does mean that the functional limits for good causes have to be provided by all of us. And this is what, Learned Hand meant when he came here in 1958 and said, if liberty dies in the hearts of men, women, and the non-conforming, no court or constitution is going to save it. We have to do that. And so that's our position as far as I.
Just a little bit more. I think partly it helps to think about like what do constitutions in actual constitutions entrench, or how does constitutional entrenchment actually work? Because they forget that the sorts of concerns that you reasonably articulate and ones that I share, right, it's sort of mob action motivated by racial animus or antagonism towards a disfavored religious minority or something like that. But importantly, there's an inverse relationship between the degree of unamendability of a constitutional text and the degree of specificity in the sort of rights guarantees of the text. You can tell there's a functional for why that be the case, but broadly speaking, right? So if we think about in the U.S. context, right? So if we say, okay, well, so we have the Equal Protection Clause to protect various vulnerable populations, but the Equal Protection Clause by itself doesn't do anything, right? What's equal protection? Who knows, right? And so in practice, what does it do? It operates simply as a license for courts to declare ordinary legislation in violation of the Constitution, right? At least under our understanding of this assumption of judicial supremacy. But that's just a decision that's just a choice about who decides, right? That's not entrenching a substantive value. That's just the allocation of decision-making authority. Again, I think premise, most charitably, I mean, Sam's story is correct. The actual historical account is not the Ely one, but most charitably, we could reconceive of this as premised on the idea that judges are, again, more attentive to the interests of vulnerable populations than our popular majorities. But again, that's just a bet, and it seems empirically unfounded, at least in this country. So in that sense, so I think all along, the only thing that actually entrenches the values that we care about is mass politics, right? Is popular majorities, and in fact, the sort of actual substantive guarantees that we see afforded to vulnerable populations come in the form of ordinary legislation, right? Things like the Voting Rights Act. It's like Medicare statute, right? I mean, it's substantive legislation that provides sort of fine-grained, detailed guarantees of rights. That's where rights articulating actually occurs. It's other than through judicial fiat and judicial discretion. And so I think in some sense, you're always sort of left relying for entrenchment on mass politics, sort of narratives about rights discovery within the court, not within
There are so many questions from this audience, so let's try to take a few at a time, and then you can all choose what you want to respond to, so. Willie's talking a bit. No, so Willie, Dan, and Amna.
Fine. What's kind of baffling to me, both as a kind of political matter and a normative, is the strongest version of the claims on the table, which is Sam's idea, which Ryan backed off to some extent, but Sam's idea of just let's sweep away constitutions. And I say Brian backed off of it, and Niko doesn't share. So Niko points out that for most of our history, Niko starts with the abolitionists, what easily just started with Jefferson, right? That the Constitution doesn't belong to the courts. The courts have no more authority to have a citizenry or the other branches in unpacking his commitments. And on forward, right? So that by the time we got to the abolitionists and the mainstream Republican Party, it was still, very much what we need are parties and organized masses to carry forward a progressive reading constitution. And by the time you get to the progressive era, what's on the table, not just for the socialists, but the word of progressive politics is this constitution is broken. But interestingly, the alternative was political constitutions. The idea was still, unless we're going to wipe out all non-progressives, we need a framework in which to continue contesting the order. But we want one, as a socialist saying, we would say today, that was far more open to mass political action and mass redistribution. And so primo was make the Constitution vastly more limited and abolish judicial review or curb it severely. No quarrel here. So the sort of fishing and format brand and a Niko brand sound very similar. And what remains puzzling to me is the poverty of the answer to the concern, the legitimate concern that liberalism is harder to escape than one might wish if one's concerned not only about mass redistribution, not only about fair equality in the policy, but also the protection of individual, and vulnerable group rights. And whether we call it constitutionalism or not, is partly a matter of what our history makes available to us, and why make it the progressive project to cure Americans of the idea that there is a legacy of rights and rights protection, rather than saying, well, we need to get rid of this juristocracy, but not a framework in which one can make claims on the past and future in the name of liberal as well as progressive socialist democratic values.
Thanks, Lily.
Yeah, so this is so interesting, and I guess I'm going to ask a version of it. This is the most contentious way of asking the question, and then I'll explain why. So the question is, who cares? And the reason why I ask is like there's a question. There's a centrality of courts and the Constitution that remains at the center of this conversation. And I think the reason why that is puzzling to me, or the reason why that like I keep bouncing off of it, because there's something else, there's another moving part here, which strikes me as democracy. And the problem might be that the people talking about the courts need to talk more about democracy, and that maybe we all agree on what democracy is. But then there's a constitutional culture, where there's a set of practices, a set of things out in the world that are not necessarily living in the courts. And they're actually barriers to the kinds of democratic gains that we want to make. And so one of the reasons why Congress won't say we're going to protect women and we're going to protect them from the courts is actually because of democracy or because of constitutional culture. And it strikes me that the project of changing that constitutional culture is not necessarily a project aimed at the court. Right, it's a project of, so another way of saying is the scales need to fall off whose eyes, right? Maybe the scales need to fall off the eyes of people in this room to make some progress, but is that progress actually aimed at the broader, larger progress, which I think to be a more radical claim than I think maybe any of you have quite stated, of like what we need to do to change how we think about democracy. Because that feels like a political movement, and it feels like tools one might want to engage in to get those changes to happen would require us just to look away from the courts maybe more than we would otherwise be thinking about doing. And so I get that's why I say who cares, like who should be listening and what should the people listening be doing about it? And is the problem really like this? So this is the sharpest way. The problem might be that post the Voting Rights Act and post Reconstruction, American political culture has been incredibly hostile to multiracial democracy, and that there are barriers to actually making multiracial democracy flourish. And that the court is a part of that problem, but if we limit our view to the court, we're actually not seeing the full nature of that problem.
There's so many questions, let's take a couple more, so I'm not listening.
Okay, so I have two questions. One is, so we're at the LPE conference, and part of the kind of framework of this conference and the part of LPE and its invitation is to kind of think about the public in relation to private, or to explode that kind of like binary that's so pervasive in the legal scholarship. And so the Constitution is, of course, like the classic expression of public law. So I just wanted first to invite you all to tell a story about the Constitution in relation to capital in the way that you're thinking about these things. And then the second thing, and it's kind of building on what Casey was asking, what Dan is asking, is to help me, maybe there's not more to say about it, but to help me to understand what is the terrain of the struggle with the Supreme Court right now? Who's actually engaging in it? Because when I think about questions of mass mobilization or social militancy around courts, what I see is that like, there is a lot of social militancy against courts, but as you all know, it's the housing court, it's the criminal court, it's the immigration court, it's maybe the bankruptcy court, and you see all kinds of social movement, kind of innovation, contestation, blockages of different sorts to stop these courts from functioning. And one of the things I agree with a lot of what you're all saying. And I constantly, every time I hear about it, I talk to you, I'm trying to figure out how do we bridge the struggles against everyday courts to the struggle against the Supreme Court. And I'm just wondering if you can help me find points of contact. One more.
So I'm still trying to find my way out of the matrix, and I can see the exit, but I'm still working through a couple of questions. One of them is I think that your project Samurai is to try to recenter legislatures, article matter, legislative authority, or judicial authority. One of the points you made here, and some of the other audience, that you've seen a bunch of cases where legislatures actually protected, enshrined, created rights, and the judicial system just will not have some civil rights being keeps anything about it. But all of that is happening atop of the existing constitutional framework, right? It's an addendum to stuff that's already existed in the background. So if we had a situation where the legislature had to do the First Amendment of the legislative package, like every 10 years or so, or constantly being challenged, it seems to me that the history would look very different. And so I'm just, I think as a practical question, are there historical examples you can point to, or even current day examples somewhere in some jurisdiction or some area where legislation have taken that responsibility of really enforcing, creating those very foundational rights, and they've been the central venue for that. Like, are there places where you've seen that happen and legislatures taking that central role, or is this still kind of speculative, something we might do and conceive of in the future?
Just, I have that number, so so here I'm just going to plug work by my friend and former colleague Genevieve Blake here, who in this sort of time, so partly so CP, right? So I think we try to highlight all of the sort of like substantive rights to vulnerable populations that have been granted by legislatures and courts. But one important aspect of that, part of it goes to the level of detail the right articulated, but another is, and this is true as not just in the US, but comparatively, if you want like positive rights, right, like funded rights as opposed to sort of your negative formal rights, those come from legislations, right? Courts are for, I think, for class reasons and for institutional competency or institutional sort of legitimacy reasons, highly unwilling to instruct legislators to massively reallocate wealth. Like that sort of wealth reallocation only comes from legislators. And so again, that sort of allows in the legislature as opposed to courts, much more often you will see an articulation or conceptualization of the sort of fundamental rights in a positive sense. And so here, so Genevieve has a paper, I'm forgetting the title of which, but sort of observing that in both the US Congress and also in various state legislatures, we see those actors articulate an affirmative conception of freedom of speech. Right, she's a First Amendment scholar. And so we see a much more sort of robust egalitarian conception of freedom of speech being protected by state legislatures, which again, famously, Supreme Court currently unwilling to enforce that. It might be much more effective, much more meaningful notion of free speech. So that's just one example, and then we talk about the footnotes.
Do either one of you want to respond to any of the other questions on the table? We can also take more. There are so many. And apologies for the last raise of hands, but we have so many on the table that I could run through some more.
Yeah, actually, I don't want to insult everyone who's asked a question before, but I do want more questions on the table. But I think just a quick response to Anna in particular about like, what is the terrain? You know, there's so much political energy right now that's bubbling up in all kinds of contexts. And one of the end goals, I think, for mass politics is, at least in some degree, legislation or legal change. And what my biggest fear is this energy exists, but it gets channeled in a way in which the possibility of the future that we can imagine is limited to what does Neil Gorsuch think? You know, which is like literally true. Like this is like literally the stuff of conversation around like how are we going to address the climate or how are we going to have these like, well, this would be a good idea, but how are we going to get Neil Gorsuch on it? And so for me, like one reason to write a book about judicial supremacy is because it plays such a big role in just shaping the vocabulary, the possibility, and the mechanisms by which legal change occurs, that it's really disempowering. And it really has the effect of making public and popular mobilization proceed through like sort of unorganic channels that may not be as effective as simply through legislation. And so that to me is like the reason to write a book in this domain, is because I want to channel that energy and push it and say, look, you know, call for what you want, and don't worry about whatever the like legal structure is at the moment, because that's amendable, it can be changed.
Sam, did you want to add anything?
I can always talk with Lily later.
The next batch that I had, yeah.
Hey, thanks for I'm very much excited to hear more about all of the projects and should read them ultimately. I want to follow up on a couple of questions primarily for Ryan and Sam. You know, partly and put you a little bit in response to the earlier question, where some of your responses were about judges. And so I want to take Lily's point. Let's assume we're all on the same page about juristocracy being a problem. Let's not worry about judging at all, or courts. And now let's move to the theory points about constitutionalism. And so I guess I'm curious on, you can say a little bit more than you have so far about what your view of democracy is, because you said democracy a lot. I'm curious, Niko defined it, but I don't know if you have the same view as him or a different view. And so what is your view of democracy? Is it majoritarian? Is it representative? Is it plebiscites? Who sets the agenda? Who decides? Second, if there is some view like majoritarianism, are you not then constitutionalist because you have a view about democracy? It's a small c constitutionalism, but you decided the basic structure of government should be democracy, and so that maybe is constitutional. So, I mean, what do you do with that sort of a recursive problem at some point? Third, I'm very curious why you said a couple times you're okay with functional. I mean, I suspect most of the people in the room in law schools or students spend time in class attacking formalists and being functionalists. And so here, though, you're very formalist. But it seems like if we care a lot about some form of democracy, back to the first question, maybe it's majoritarianism. Second question, then maybe we should care about functional entrenchment also as a way of stopping the will of future democracy, future majorities to do things. If there's some intervening mechanisms, whether it's wealth or institution building or who knows what. So I just wonder if you could say a little bit more about those things.
We'll take a few more. Apologies, I don't know all your names, but black and white shirt, colorful notebook.
So I guess the question is that the hardest version of the thesis, which is that you abolish constitutionalism. Is there a little bit of a theoretical risk of, in that process, agreeing with the temporal quality of liberalism to say that at some point of time, people do become fit for self-rule? And the idea of delaying that process across the world and somehow keeping constitutionalism in the US equates all of the US electorate with the rest of the world, which is its possibility of self-rule is postponed in some sense and perennially postponed. By suggesting that it is possible, you sort of exercising specific sovereignty over time within the United States and suggesting, that surely there's some parts of the world that, would be a very offensive idea to sort of go to majoritarian self-rule for whatever conditions that it is in. And so what's the risk at a sort of global stage on that?
Thank you. Sure.
Thank you so much. I have two questions. One is when I've tried to argue the anti-judicial supremacy position after being radicalized in Professor Bowie's conduct class, it's fascinating and a lot is that it's the epistemic justification for judicial supremacy. And what I mean by that is that courts just may be better positioned epistemically than legislatures to get the correct answer to the question at issue. So because a lot of people try to frame this question as a legal question at the end of the day, like even in the context of Shelby, if it's about 15th Amendment and meaning of appropriate, it's a legal question, right? And then my opponents always say, but since it's a legal question, aren't Supreme Court justices educated in the institution better positioned, better members of Congress, like Marjorie Taylor Greene, to really grapple with what this means in the Constitution? And then the second question is, how do you keep legislation within the rule of law without judicial supremacy? So, for instance, if the Knesset, the legislature of Israel, wants to build illegal settlements in Palestinian territory, how, without a counter-majoritarian institution like the courts checking majoritarian persecution of minorities, how can we still have the rule of law?
Thank you. So I have a question about what you do, how you speak to the anti-democratic nature of the US Senate. So in the short term, at least, until we get rid of the Constitution, and everything, like you didn't do the whole budget. Is it just that the legislature or the US Congress is just the lesser of two evils between the Supreme Court having supremacy and the legislature? Or is there like another play to actually then fix this other very anti-democratic, although slightly less very anti-democratic than the court? Would you like to speak or should I take a couple more? We have about.
Yeah. Oh, sure. So, so I think one response as a whole is, I tend to think of sort of where we are institutionally relative to where I would wish we were, like where we should be, where we're aiming for. And so I think like the ideal version of, our polity is very different from the one we have now. Like my ideal national legislature would look almost nothing like Congress. But there's sort of the second question of how do we get from here to there? And you could imagine, like you could put on the table, like the possibility that courts interpreting the US Constitution are going to move us. Like they are going to be the engine from getting from here to here. And I think that is implausible. Like by any account, like you could, reincarnate Earl Warren and multiply him by 9. We're not going to here. We're going to like start there. And so in thinking of like how to I think that this is the risk that accompanies any conversation about removing barriers to mass politics. Like, you can make the same point about the filibuster or about bicameralism or about just any structure that is designed to impede majority rule. And say, but doesn't this stop bad things from happening? Like, maybe, but it really stops anything from happening. And the net result of that is beneficiaries of the status quo are fine, because it's hard to change anything. And so if you're happy with the status quo, these sort of like forms of entrenchment are less risky than if you're unhappy with the status quo. And I think enough people, including myself, are unhappy with the status quo that like the risk of not doing anything is seriously like more pressing to me than the risk that majority rule would result in worse outcomes than the present.
Just super quick, one sharing. So A, yeah, it's comparative, right? Again, so like among two bad options, this one is left bad. Now, in addition, though, like in the sort of your kind of piece that Sam and I wrote on sort of critiquing constitutionalism, we also pointed to one of my favorite pieces of legal scholarship in the past decade, which is a note in the Harvard Law Review called Happy Union, right? Which is one illustration of the creative strategy to break the Senate, right? Because I do think that the Senate is as much or more of a problem than the court. It's like I'm focusing on the court in my work with Sam, but that's sort of in a way like our comparative expertise. But yeah, this has to be part of the broader project. And I think in a way, I think the two have to travel in tandem, because I think the court reform project is obviously tremendously hindered by the current structure of the Senate. So I don't think that they're actually sort of meaningfully acceptable. On the point about isn't this a technical question that should be left to courts? So one is I really appreciate that case to describe our collective writing as refreshingly realist. And so that's the answer is like, no, it's not a technical question. These are like incredibly vague texts and we're just making it up. We're just deciding. No one's discovering law here. But this also goes to Lily's earlier question about what are the risks of having the discussion be about a legal text. The risk is that sort of technocratic story has plausibility to a mass audience, right? Versus if we can shift the discourse from law to morality. What's good? What's just? What does real democracy look like? There, that sort of mystification move is unavailable, I think.
So heading towards Ganesh, but answering a number of questions, including Willie. I mean, I think we're in favor of baby steps in the matrix. Not that makes no sense. A coalition against juristocracy and some of the kind of institutional reforms that we all favor. We don't think it makes much sense to think that we'll get there by appealing to old visions of the Constitution. Bernie Sanders never mentioned the Constitution in his campaigns. I query whether we need to sustain these, ideas of legislative and political constitutionalism if what we mean by that is that the present majority rules. If that's what we mean, why does it need to translate its will through an interpretation of tradition, which is just self-deceptive? If you claim empirically that will favor those outcomes, I mean, it's bizarre that it would, and the track record is horrible, then maybe you're right, but we don't think so. On democracy, I guess I'd say it's an indeterminate idea that means self-rule. What we all can agree about, increasingly, is that empowering judges is a mistaken institutionalization of that idea. And then we're in a struggle of, what are its constituent features? I, for one, don't want to build a lot of conceptual content into it and say, well, we can be Democrats and liberals morally or egalitarians morally. But what we should most care about is developing our general conception through statutory law. And that's the argument against functional entrenchment. So, against formal entrenchment. For now, clearly, I think there's a big consensus that whatever else it involves, democracy involves representative institutions where decisions are made by majority rule. And we might have very good reasons to functionally entrench those conceptions. We might not. We might have reason to experiment with democracy in various ways, try other ways of institutionalizing it. Regardless, that would be something that we would have to find out as time goes on. So that's why I'm focusing for thinking about the juristocratic problem on formal entrenchment. And then we have to have a decision later and a debate later about, well, what exactly are the ways we want to have stable democratic governance going forward? What are the ways we have to overhaul and save it? And maybe there'll be kind of general disentrenchment ultimately, because that might be the best in the very long run.
Just really quick comment on entrenchment, sitting and work with my friend. So I would your concern was that we were engaging in a sort of empty formalism, but I don't think so in the sense of that the sort of entrenchment, like formal entrenchment is sort of like flagrantly like anti-majoritarian, like that's the character of it. By contrast, right, I would point to work by people like Ben Sachs and Kate Andreas, who sort of explore ways in which one might use the law to create political constituencies that could then defend in ordinary politics the sort of values that we care about. Things like, sort of building up unions, most obviously, as creating a sort of political force. But in a way that is the sort of, at least for us, the sort of theory of progressive entrenchment is one just a sort of mass politics and popularity. And so I don't view that as anti-formalism, right? I think like a theory of entrenchment grounded in popularity in ordinary politics is a squarely democratic theory of entrenchment as contrasted with a sort of openly anti-majoritarian.
We don't have a lot of time left. I had Asla front row, and I know there were some questions from the middle section, but I apologize. I was overwhelmed with hands and carried this with away. So maybe we'll start there, and then if you have a question in the middle, you could raise your hand again.
My question was, for Niko, it's sort of the conversation, what emerged with that, you were positioned on this panel as someone who's prepared to still defend a version of constitution, not the local constitution, the idea that constitution as itself could be a vehicle that you would come from. I just wanted to explore what you had in mind by that. And you also are the only person in the panel that invoked sort of comparative constitutional law as a source of, at least in reflection. And so I want to know that many other parts of the world, the Constitution doesn't have the characteristics that Moyn and Sam were describing. They're not necessarily abstract. They're not necessarily entrenched in quite this way, although they're often entrenched to some extent in this idea of progressive entrenchment. But they're super values oftentimes. They're relatively much more amenable. But the desire, the idea of what the Constitution is serving as an instrument is, it's kind of an instrument of political education, as much as it is of local constitutionalism. And it's specifically because it's disrupting authoritarian trajectories prior to it and trying to create a path-dependent capacity to progressively continue to realize an alternative path. And it's difficult to do that unless you can get a recursive process going, which requires a certain amount of getting off the ground momentum. So I just wondered how you were thinking about what the value could be of the Constitution, and particularly because while we think about other places that have a problem of partially consolidated or unconsolidated democracy, earlier comments I think from Dan note that this country cannot achieve multiracial democracy, and partly because it may not actually be a popular project at this time. And so the question becomes, like, how do you build momentum for a popular project? And is there a space for thinking about a constitution differently, certainly away from juristocracy, but differently as serving as a tool that's used sort of reconstructing a different way here?
So I had a version of a very similar question, but maybe I could put it to Ryan and Sam and ask it like this. So given the provocations to think historically and to think comparatively, are there contexts in which you would see constitutionalism as one of the functional ways that people strategically fight about progressive entrenchment, expecting that it's going to be far more provisional and anticipatory, in a really different way than American liberals perform naturalized permanence and endurance?
I feel that I've neglected the middle section. Were there hands there? There were before. Luke.
Okay, so just very briefly, I wanted to bring up a topic that was the cause of Ryan and my initial encounter, which is there's currently the Biden plan to cancel student debt is being challenged by the Supreme Court. And it's interesting that all of you said, well, it'd be nice to have these conversations more in movements. in my experience is that all the folks who are doing student debt mobilization work are like, how do we get law professors to say fuck the courts so that we can ignore them, right? And so like, I don't know, like, how do we build this, like, how do we build that? I mean, I just want to say, first of all, I appreciate that, like, the fact that you're out there makes it easier to do that. But like, how do we build those connections and make it easier for people like us to say, you know, ignore this Biden, or, you know, ignore this Congress, like, you know, proceed with the Voting Rights Act.
I saw a hand up there and a hand over here and always. I'm gonna have to call it a day with Gretchen and Frost.
Yeah, so for those of us who are not jurists and are or will be practicing lawyers, I'm curious how you hope or imagine your ideas will be picked up and used by lawyers who, kind of to get on this question, are on a daily basis confronted with the courts, you know, whether that's what arguments get raised, how they're raised, legal strategies.
Thank you. So I am actually picking up on Willie's comments earlier. Even though I am much more sympathetic to your take, I keep thinking, when I teach a comparative law class, one of the things that frequently comes up is how much law, and particularly constitutional conceptions of law, are a part of the US culture, right? People are always declaring their rights. So then I wonder, is there a way not to lose the value of that? Well, I guess, do we lose something by kind of pushing against the grain of constitutionalism from a building of a kind of, as Oscar put it, like a kind of robust, self-confident populace that's able to self-govern?
It's super quick last week.
Tune into Willie and Aziz on this panel tomorrow, where I think Aziz will have sort of a couple of I think in this.
I think, again, I would just say, my view of constitutionalism, for whatever reason, has been really heavily influenced by the industrial workers of the world, who were famously opposed to labor contracts. So it's a labor union that didn't like contracts. And the theory why they didn't like contracts, at least some of them at some point, was because it would like sap the energy from organizing. So a contract is only as good as the leverage behind its strength. And so they argued that by putting things in checks and leaving it there, hoping that because it was in checks, it would therefore be enforced, was, you know, disempowering in the sense that it led people to not organize anymore, not think that they needed to maintain this leverage. And I think that's my view of constitutionalism, is like, at most, all we can hope for is a method of organizing mass support in favor of a particular project, but we can't rely on the Constitution itself to achieve that, or hope that by entrenching something, the outcome will organically result.
I want to thank you all. I'm sorry for the questions we didn't get to hear, but hopefully the conversation will continue, which is the mark of a great panel. Thank you all.
Thank you.